What this fight boils down to is the difference between commercial and business rights versus our natural, collective, inalienable, non-transferable rights of our people. The right to our language. This is even what the United States' Constitution is about. John Locke, he believed that we all had inalienable natural rights that were God-given and can never be taken away. That's what we believe in regards to our language. Our people have always been philosophers. But in this memo from Lexi Orville, he says that our sacred language connects to our umbilical cord to the sacred ancestors, the Tukhunka Oyate. These spiritual connections and rights belong to our children and should be protected. With a piece of paper, can that disconnect us from our language, which connects to our umbilical cord to our sacred ancestors? Tribes don't think so. Standing Rock Resolution 150-22, it says the LLC TLC products are generated for sale to our own people and to a global commercial audience without any provision to protect or maintain sacred stories or knowledge as an inalienable, non-transferable, collective Ochedi Shakoi birthright for our children and grandchildren. Cheyenne River Resolution 91-07-CR. There are many significant and or sacred Lakota ceremonies, songs, and stories that must be identified, preserved, and protected from misappropriation, exploitation by those who seek personal or financial gain from their use. The Lakota Oyate must protect and preserve our other cultural property, whether in the form of language, ceremony, stories, songs, physical sites, sacred. Down here, Cheyenne River Sioux Tribe recognizes the need to declare, reassert, protect, and preserve the Lakota Oyate's ownership of Lakota culture, language, and ceremonies. Rosebud Resolution 2008-295. This talks about the gathering of our intellectual property. It should be reviewed and approved by local collaboration group in Sintegaleshka University for approval, and that the RST will provide a letter of support for the protection of all intellectual, verbal, and artistic knowledge of the Lakota language, history, and culture. Further up in their resolution, they talk about the issues of non-Native American sources entering the reservation and school systems with their own welfare in mind, and their entities are utilizing individuals' names without consent for the sake of contributors lists to mislead the public and further receive support of unsuspecting school districts, school boards, or programs. So when state-based corporations plop down waivers like this, they're seeking to disconnect us from our natural, inalienable, non-transferable rights to our language. These are commercial and business waivers that gives them unrestricted permission to copyright in all current or future formats forever. These nonprofits derive their power from the state articles of incorporation. They threaten me with the cease and desist to litigate in state court. So despite these resolutions from Standing Rock, Cheyenne River, and Rosebud, they continue to sell and commercialize our language and stories and songs.